Hi, my name's Megan Bever. I am book review editor for the Journal of the Civil War Era. Today, I'm having a conversation with Juliana Perrone, who is assistant professor of history at UC Santa Barbara. Her areas of specialization are law, slavery, the Civil War, and Reconstruction, and she's currently working on a project exploring reparations. Today, though, we are here to discuss her 2023 publication, Nothing More Than Freedom: The Failure of Abolition in American Law, which was published by Cambridge University Press. So we'll start out really broadly. Can you tell us a little bit about how you became interested in exploring the process of abolition during Reconstruction?
Yeah, like all good projects, I think it was an accident. I originally, when I went to graduate school, thought I would be working on more 20th century things, and needing to do a seminar paper, I found this sort of pile of court cases that related to slavery that were decided after slavery had supposedly ended. And I got to abolition with a very simple question, which is, why are these cases still here? Like, why are we still adjudicating slavery if the 13th Amendment has gone into it? Like, what's happening here? And that is the sort of origin of a longer story that was, sort of a winding path to abolition. Is like, oh, because in fact, what emancipation does is end the ownership relationship, the property relationship that is inherent to slavery, but doesn't actually address all of the other things that make the institution what it was. And that realization is really what pushed me from dissertation to the book on abolition.
So can you talk a little bit more about this focus? You focus on private litigation, whether those are contracts or even like marriage laws and anti-miscegenation laws. Can you talk a little bit about why you chose to focus on private litigation?
Sure. So I built a database actually, and I started, I mean, very rudimentary. I sort of built my own sortable database where I could make a big collection of all of the cases that I found that were related to slavery being decided during the Reconstruction period. And a whole lot of them, once they were sort of arrayed in front of me, had to do with private arrangements between individuals, not big, sensational criminal kinds of cases. With some exceptions, the criminal cases that I do include are related to interpersonal relationships. And one of the things is I started reading more abolitionist scholarship and thinking through sort of the larger implications about of talking about abolition. You know, modern abolitionists have really spent a lot of time unpacking the criminal justice system and talking about prison abolition and have focused on that area of law a lot. And what I had in my archive were a bunch of questions about the legacies of slavery that were being raised in disputes between individuals, between residents of a particular community. And that in fact, a lot of the questions about, well, what is the meaning of the 13th Amendment going to be? What sort of, what does it mean for slavery to end? Does it just mean we're breaking the property relationship, or does it mean something more? Those those questions are being taken up in these cases related to things like people's contracts for the sale or hire of an enslaved person and whether or not they still have to pay the money that they owed. And that was not something I expected to discover or find, but that was really what was in front of me. Um, and again, this is for me, it was important, or at least I see this as a way to add to this conversation about abolition, perhaps in the present, as requiring something more than just attention to the criminal justice system, but also requires a really thorough excavation and interrogation of the ways that things like contract law, which appear to be divorced from slavery entirely, actually are implicated in this history.
One of the things, I mean, I love that you've pulled it to the present, right, in our current abolitionist movement. One of the things that I also think is a strength of the book is that in that sprinkled throughout, but especially in that final chapter, you really point to how these private cases and private litigation, they have national ramifications at the level of the Supreme Court, even during and as Reconstruction is ending. Can you talk a little bit more about that?
Yeah, so the questions being decided at the state level, like are the contracts for the sale or hire of enslaved people going to be valid or not, ultimately make it to the Supreme Court because there are so many of them. I mean, every state is contending with this question, every former slave state that is. And so there was sort of no way this wasn't going to get a final answer from the Supreme Court. And when it finally does, the answer is yes, you do have to uphold those contracts. Money for enslaved people must continue changing hands. The economy of slavery will continue beyond beyond emancipation for reasons that are related to an interpretation of the contract clause in the Constitution itself. Um, but these but what that means more broadly is, as I'm arguing, a limited reading of the meaning of the 13th Amendment and its potential. So, for example, Justice Noah Swain, who's a Supreme Court justice, initially in a federal case in 1866, envisioned the 13th Amendment as being really powerful, as in fact granting citizenship and really dismantling the superstructure of slavery in a much more capacious way. By the time he's ruling on these contract cases on the Supreme Court, he has been persuaded or at least comes to see the arguments coming out of the state courts that no, you can't just get rid of these contracts as persuasive. So he actually shifts over the course of Reconstruction and says that the business of slavery actually can and should and must continue. The other cases are, I mean, some are really the big ones, right? Slaughterhouse, the
Right.
civil rights cases, that we know. Others are I think more obscure, and most of us don't so I teach a legal history class. I don't teach Texas versus White in a legal history class. And this is a case that decided whether or not the Confederate States were in the Union or out of the Union. This decision has huge implications for how courts can address all of the things that happened, the legal arrangements that were made during the war itself. And how Congress can treat the former Confederate States. So this becomes an essential piece to answering that contract question that I've already spoken about, but lots of other things as well. It changes what's possible, and we don't think about it. I mean, I suppose I mean, I know that there are historians who think about this case, but it's not the blockbuster of Slaughterhouse, right?
Right.
Yeah.
Um, I'm gonna not take us on a tangent, but I think what was surprising to me was, I mean, in the one case, like how much your study talks about white people continuing the business of slavery, like you've been talking about through their
Yeah.
contracts and through debts. But the second half of the book also really looks at kind of what these cases mean for Black families,
Hmm.
what it means for marriage, what it means for inheritance, and then also what it means for non-traditional or mixed race families. So this takes us back to the local a little bit. But can you talk a little bit more about those kind of very personal ramifications for African
Yeah.
American lives?
So full disclosure, these are my favorite. This was the material, the archival material that I enjoyed working with the most, but precisely because you are being introduced to people's most intimate lives. So questions about whether or not marriages or, previous relationships that formed during slavery, relationships that form after slavery between formerly enslaved people, or sometimes between interracial couples, provoke a lot of questions. And states don't have a uniform way of addressing what to do with the sort of domestic lives of formerly enslaved people. They have no legal past. Officially, they have not been allowed to marry or have custody of their children or own property, let alone bequeath that property. And yet those rights, those sort of basic domestic rights to marry, to have children, to inherit, they are elemental to being free. So states will begin adopting statutes actually as part of the Black codes to validate the marriages of enslaved people, or at least to set the rules for how that's going to happen. And they're not identical. There are some variations, but the kind of impulse there is both to end the fragility of the Black family, but also make sure that Black people's domestic relationships are being controlled by the state. So there's this weird tension where everybody agrees from all sort of different vantage points that, yes, we need these marriages to be legitimate. We need people to be living in legitimate households, that this is a sort of essential part of being free, and becoming and belonging, right? At the same time, it must fit in this certain kind of box. It must look the way normative marriage and family looks, and meet certain standards that predate emancipation. And the big problem is that the customs of slavery don't necessarily look that way, do not necessarily conform to the normative picture that would have existed in lawful society prior to emancipation. So there are all of these problems that can't be addressed. For example, one of the cases that I talk about in the book that was really kind of stirring is a formerly enslaved man who had a wife and children who were sold away from him. And after he became free, prior to the Civil War, he married another woman. After emancipation, he ends up in divorce proceedings with the new wife, saying, I can't be married to you because I was already married, actually, in my heart, to this other woman and my children. And unbeknownst to me, they were not dead, that they are still alive. And therefore, I am not actually married to you, I am married to her. And the court does not know what to do with this, right? They're like, well, we don't have an answer to that. The only marriage that we can sort of identify and recognize is the second one. That there's no answer for the fact that your relationship with the person you consider to be your wife and your children was torn apart by slavery. Likewise, there's no answer for enslaved people who don't believe that their marriage, whatever relationship they were in after, during, and immediately after slavery, is legitimate. They don't believe they need to get a divorce, for example, in order to marry another person. So there are all these bigamy charges against people whose ideas about what's necessary to end a relationship are based on notions that evolve within enslaved communities. And they don't believe they need to go and have any sort of like official, dissolution of a marriage in order to have a new relationship. So what I ultimately found was there's no way to fully address those problems. You can get closer than to making the law equitable for freed people, but it can't actually be perfect because the past, right, the lack of legitimacy in the past, it comes with what are called legal disabilities. And courts, judges, even when they want to, and it's in these cases where you see judges trying the hardest, even when they want to, can't necessarily overcome those previous disabilities with the tools that they believe they have at their disposal. Now, of course, when it comes to interracial relationships, it's a slightly different story. Judges are working really hard to make sure that they remain illegal. And there's this problem of, well, if freed people are citizens and have the right to marry, and marriage is a contract, a civil right, you can't deny marriage to anybody. So it takes a while to come up with the strategy, the winning strategy for that. But we know that story a little bit better, I think.
So one of the surprising, or at least for me, one of the surprising parts of the book are these peculiar abolitionists who show up in the Reconstruction South. I mean, I will fully admit this may kind of show my own limitations. I was not expecting Joseph Brown to make a cameo in your book. But and you've got Louisiana in particular and some peculiar abolitionists there. But can you tell us a little bit who they are, what they are, and in what ways they complicate our understanding of the process of ending slavery?
Yeah, so I refer to a group of judges as peculiar abolitionists, and they are almost all of them not carpetbaggers. In fact, I found there are far fewer carpetbagger judges than I would have imagined. There are some. There's one particularly in Mississippi who's interesting, but for the most part, these are judges who had been enslavers prior to the Civil War, who typically believed in union, but not always, but who, upon the end of slavery, become fully committed to eradicating it for a variety of different reasons. So the judge in Louisiana, James Taliaferro, is persuaded that slavery has to truly be reckoned with because of the violence in Louisiana following the Civil War, right? The riots in 1866, right? He's living through this. And he comes to see the legacies of the Confederacy, the legacies of the slaveholding republic as something that has to be eradicated. The court reporter for the state of Texas, he also functions as an attorney in Texas versus White, and he was a Supreme Court justice in Arkansas before this. He has sort of the same pathway. These are like what you would sort of categorize as they become conservative Republicans, basically. So they're not necessarily ultra radicals. I'm not suggesting that. What I am suggesting, though, is they adopt a belief that slavery has to be eradicated fully, that you have to address the lingering sort of legacies, remnants of slavery that exist within the law, and you can give no more credence to anything related to it. That you have to do that work of dismantling and then apply the kinds of equal protections that congressional laws and new federal amendments are laying out right from Congress. So they ultimately buy into a kind of radical vision for Reconstruction, not because they're radical in terms of racial equality, though some are, but because they believe that this is the only way to return to any kind of social stability and also to abide by what these new laws are really trying to do. And they see value in what the new law is trying to do. But again, these are all former slaveholders, and Taliaferro in Louisiana, his sons were fighting for the Confederacy. He was jailed by the Confederacy at one point during the war. I mean, these are people who have really lived through the sort of tumultuous war years and the kind of transformation really comes from their terror at what they're seeing, right? And violence, I should say, is key to that. They're increasingly concerned that the violence that had been endemic during the war is simply persisting in other ways.
So, as you were going through the process of researching and writing, what did you find the most surprising?
In many ways, they were the most surprising. The so-called peculiar abolitionists. That and this is another aspect of them that is worth thinking about. They are really dedicated to the rule of law. They are committed to notions of judicial fairness and to the meaning of the 13th and 14th Amendment and civil rights laws in particular, in a way that I found surprising. That these are former slaveholders who are capable of recognizing that the law has changed and that you cannot go backward. Um, Brown, who you mentioned, is not necessarily one of them.
Right.
He has very different arguments for why he believes the things he does, which are predicated on the notion that the Southern cause is valid, but was simply militarily overcome, right? But he is interesting, if for sure. But the fact that there is this group of people and lawyers too, and they were the hardest. I could really not find much about the lawyers, but um, arguments are being made by Southerners, by Southern judges. Decisions are, and verdicts are being handed down that really take seriously Black equality and Black freedom in a way that I was sort of not prepared to see some of the language. Um, there's an Alabama judge, and he actually comes to see gender equality as something worth pursuing. Also, he I wasn't prepared for that. I sort of expected that these Southern judges, these former slaveholders, these members of the plantocracy would sort of be, keep that fealty to that class. And they don't. They don't.
Yeah, I would. I mean, in reading it, I would say that was one of the. It was also a really surprising component. Just and reminded me of James Longstreet in some ways and
Yep.
his transition after the war. But yeah, it was really interesting. It was a fantastic study, all around. I really enjoy it, and again, it can change the way that or change the way that we think about Reconstruction and the way that we teach Reconstruction in the classroom. Thank you so much for sharing some time with me today.
Yeah, you're welcome.